Court calls the case of the people versus Nadia Cosley.
Before a single name is called, this courtroom already tells us what kind of morning this is going to be. This isn't a single dramatic trial with one explosive moment. This is a rapid-fire docket where real people cycle through the system one by one, and every case carries consequences that ripple far beyond these few minutes on the record. Licenses, freedom, housing, employment, family obligation, all of it is on the line today, and most of these defendants are balancing legal trouble with everyday survival. What makes sessions like this fascinating is how quickly lives are reduced to checkboxes. Insurance paid or not paid, bond continued or revoked, travel allowed or denied. You'll hear judges switch from stern authority to unexpected humanity in seconds. You'll hear defendants stumble through explanations that are messy, yet incomplete, and very human. And you'll see how the justice system manages volume, not just guilt or innocence, but logistics. As we move through these cases, pay attention to how responsibility is framed, who owns their mistakes, who's still scrambling, and how much patience does the court extend before consequences harden. Because today isn't about one bad decision. It's about patterns, progress, and whether the court believes someone is genuinely trying to get their life back on track.
Good morning, sir. Yoo-hoo.
Oh, this. What was the picture under?
Cosley.
In the 10 a.m. block. Oh, that's me. I'm sorry, Your Honor.
No, it's okay. You guys were in some, I don't know what kind of conversation you were in. You were in some conversation. I was willing to wait. The only reason I said anything is because of Alan. No.
Well, thank you, Alan. I appreciate the heads up. Good morning. Assistant Public Defender Lauren Perry on behalf of Ms. Cosley, who should be on Zoom.
She is.
So we're here for one, well, I'd ask her to state her name first, please. Ms. Cosley, can you unmute and state your name for the record?
Nadia Cosley.
All right.
So we're here for trial, and then there's a,
There's another case.
correct. We've waived formal reading and stand due to those charges, Your Honor.
All right. On our other matter, that being the case ending in 513, defendant waives formal reading, stands mute.
And then as for pre-trials, I'd ask for an adjournment of both cases. She's working on getting her license back.
Okay, where is she in that process?
Ms. Cosley, do you know what you need to do to get your license back?
Yes, I just have to pay my insurance ticket. I got it suspended because I didn't pay the ticket. I'm just working with my manager to get my money. I've just been working. I'm in college and I'm paying rent.
Okay, hold on.
So I'm just getting the money to pay the ticket.
You said a lot there. Hold on a second.
I'm sorry.
No, it's okay. So you got to pay the insurance case because you're suspended because of that, right?
Yes, because I got into an accident with no insurance and I never paid the ticket.
Got it. And that's the ticket we just arraigned her on? Or is it another?
There's another no insurance, I believe. But I have insurance now. I have car insurance now.
Civil infraction, no proof of insurance. Civil infraction, no proof of insurance.
Yeah, she didn't pay that ticket, so then Secretary of State suspended.
Suspended her license and now we have this new one.
Yes.
Okay. All right. So how much time is she going to need to straighten this whole mess out she's created?
That line lands hard, and intentionally so. Judges use language like this to reframe the narrative. This isn't bad luck, it's accumulation. Multiple unpaid tickets, multiple suspensions, multiple chances. When the judge calls it this whole mess, he's signaling that leniency is conditional, not guaranteed. What's interesting is how humor and humanity slip in immediately afterward. Subway pays well, birthday money, a light moment, but not accidental. Judges sometimes allow levity when they sense honesty rather than excuse-making. It doesn't erase the legal problem, but it humanizes the defendant enough to justify another adjournment instead of harsher action. Then comes the bond decision. A personal recognizance bond on the other matter is significant. That means the court is trusting her word rather than demanding cash. That trust is fragile. Miss the deadline, fail to pay, or drive again illegally, and that grace disappears fast. This is the quiet tension of traffic-related cases. They look minor, but repeated noncompliance turns them into serious legal traps. One missed payment can spiral into license loss, job loss, and eventually jail time. Ask yourself, at what point should the court stop extending deadlines? And how do you tell the difference between someone struggling and someone ignoring the law?
And I will say for the record, she does now have insurance on the vehicle.
Oh, okay, well, good.
Right, so she's making progress. She just has to get the money to pay that ticket off.
To pay that ticket out. Can she do it by the 18th of June?
Mhm.
Subway pays well. She'll get it.
My birthday
June
is also this week, so I'll get birthday money.
What'd you say?
My birthday's next week, so I'll get birthday money.
Oh, well, happy birthday.
Thank you.
June 18th, 2025, 9 a.m. Bond continued. All right, thank you. Well, I'll have to set a personal recognizance bond in her other matter. I'll just give a personal recognizance $5,000 bond. All right, thank you. Court, let's call the case of the people versus Sean Charley.
Connor, it's still on behalf of Digital Township.
Which one's in the ring?
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Charley. Mr. Charley, please state your name for the record.
Before we go on to the other case, Mr. Charley, you have a new matter before me. That case alleges that on or about March 24th, 2024, at the location Carpenter Road in Pittsfield Township, that you did possess drug paraphernalia. You understand the nature of that charge, sir? I do.
This is a textbook arraignment, but there's more happening beneath the surface. Drug paraphernalia charges are misdemeanors, but they often signal deeper issues: substance use, unstable housing, or ongoing contact with the criminal system. The judge's tone is calm, procedural, almost mechanical, because this stage is about preserving rights, not passing judgment. Listen closely to what the court orders next. Standard bond conditions: no weapons, no alcohol, no marijuana, no illegal drugs. That's not punishment, it's prevention. Courts use bond conditions to control risk while cases are pending. Violate them, and the consequences escalate fast. What also matters is timing. Multiple cases, multiple dates. The defense wants everything aligned after June 5th. That's strategy. Managing court dates reduces chaos and helps defendants avoid accidental violations simply from confusion. This is where the system either helps someone stabilize or overwhelms them. One missed appearance, one positive test, and suddenly a minor misdemeanor turns into jail time. Audience question: should courts bundle cases to simplify compliance, or does repeated involvement with the system justify tighter control?
And that's a misdemeanor punishable by up to 90 days, $500 fine plus court costs. You understand that, sir? I do. All right. Do you wish to be represented by an attorney? I do. All right. This is a public defender case.
Your Honor, pertaining to the arraignment, we'll waive formal reading and stand mute to the charges.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea.
As for all the pretrials, we're asking to adjourn all of them. Mr. Charley is up in court, and we're kind of just seeing what happens on those. His next dates on those are June 5th.
Right.
Well, he has some May 29th. The latest date is June 5th. So I'm asking,
June 18th date.
I'm asking
Want a date after those.
after June 5th, right?
All right. So, well, on his new case, I'll order standard conditions: no assault behavior, no possession of weapons, no alcohol, recreational marijuana, or any illegal drugs. I'll adjourn all of these matters then to June 18th, 2025, 9 a.m. Bond and the other matters will continue.
Thank you, Your Honor. Thank you.
Court calls the case People versus Billy Cobgully.
Ashton, on the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Cobgully, who should be present via Zoom. Sir, can you please unmute and state your name for the record?
Billy Cobgully.
Thank you, Your Honor. As to the case itself, there is a resolution to which my client will be pleading no contest to the added count 2 of OWI, and in exchange, count 1 will be dismissed.
A no contest plea is one of the most misunderstood moments in criminal court. It sounds neutral, but functionally, it's almost identical to pleading guilty, especially for sentencing. The key difference is civil liability. By pleading no contest, Mr. Cobgully avoids admitting fault that could be used against him in a civil lawsuit, such as a crash-related claim. Judge Simpson carefully explains every consequence: jail time, fines, license sanctions, vehicle immobilization, even reimbursement for emergency services. This isn't dramatic, it's deliberate. Courts must ensure pleas are knowing and voluntary, or they risk reversal later. The repetition you hear, "Do you understand?" isn't filler. It's legal insulation. If this plea is ever challenged, the record will show the defendant was fully informed. And B, this is also where OWI cases quietly reshape lives. 6 points. License consequences, mandatory screenings, impact panels. Even without jail, the ripple effects last years. Viewer engagement. Do you think first offense OWI penalties focus more on punishment or rehabilitation, and which actually reduces repeat offenses?
That's correct, Your Honor. That added count 2 of operating while intoxicated first offense, 93-day misdemeanor, $100 to $500 fine, 6 points, and various license sanctions is contrary to MCL 2576251A. I believe it will be a no contest.
Sir, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
All right. State your name for the record, please.
Billy Cobgully.
All right. Sir, it is this court's understanding that you're going to be pleading no contest to the charge of operating while intoxicated. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The court could order any rehabilitative services or community service the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes, sir.
Do you understand what a no contest plea is?
Yes, sir.
2 things about a no contest plea I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. Do you understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, sir.
Basis for the no contest plea.
Potential civil liability, Your Honor.
Sir, to the charge of operating while intoxicated, how do you plead?
No contest.
Now you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
That is correct.
Any question regarding any of those rights?
No, sir.
Looking at paragraph 5, those are your rights which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead no contest?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
All right, the court has been handed in, or has been provided and has reviewed Michigan Department of State Police report for their case number 9303-24. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
On a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
Before satisfied.
Yes, Your Honor.
This is the moment the plea becomes irreversible. Once the court finds a factual basis, the legal door to trial closes. Count 1 is dismissed, but only because count 2 stands solidly on the record. Notice what happens next. Referrals, alcohol screening, victim impact panel, sentencing scheduled later. This separation is intentional. Courts often accept pleas first, then pause before sentencing to gather rehabilitation data. That data can mean the difference between jail and probation. Also important, bond continues. That means Mr. Cobgully remains under court supervision until sentencing. Any violation now could undo the benefit of the plea deal. This is the system at its most procedural, but also at its most consequential. A few calm answers here determine months or years of legal aftermath.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to Von Schwartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be June 25th, 2025, 9 a.m. Bond with its conditions will continue. Mr. Gully, wait. I need you to wait on the line. We're going to put you into a breakout room with my probation department so we can start the sentencing process. All right, sir?
Okay, thank you.
All right, thank you.
Thank you, sir. Thank you, Your Honor.
Thank you. Court calls the case People versus Stephen Grisbeck.
Conrad Silver on behalf of the Township.
Good morning, Assistant Public Defender Lauren Penny on behalf of Mr. Grisbeck. Mr. Grisbeck, please state your name for the record.
Stephen Grisbeck.
What are we doing?
Your Honor, we're asking for an adjournment of this pretrial of the possession of drug paraphernalia case.
Okay.
He's currently serving a sentence on his domestic violence case.
Here's where collateral consequences hit hard. Mr. Grisbeck isn't just dealing with criminal penalties. He's facing the loss of Section 8 housing. That's huge. Housing instability often triggers a cascade. Missed appointments, violations, rearrest. The court isn't minimizing the DV conviction, but it is recognizing reality. Completing classes, timing release, coordinating with housing authorities. These aren't legal technicalities. They're survival mechanics. Judge Simpson's willingness to adjourn isn't softness, it's triage. The court is trying to prevent one case from detonating the rest of a person's life. Engagement question: should courts actively help protect housing stability, or is that beyond the justice system's role?
I've been in communication with, and just, I guess for the court's knowledge and Mr. Grisbeck's knowledge, I have been in touch with Ms. Pilara. He's at risk of losing his Section 8 housing. I know Mr. Bernstein handled that DV case. I know the
Right.
court's aware of that. So she may, if he continues with the domestic violence classes, may move up his review hearing to June. May recommend that the
We were
court.
trying to move his case closer so his certificate or in the house
I have-
wasn't in jeopardy.
I have 9 days before the 93 days is up.
I have him in custody for 55.
Your sentence is up in 9 days?
The voucher.
Oh, the voucher. You have 9 days left on
4
that.
days.
Are you saying that because of the amount of time you've been in custody?
Correct.
So how much longer do you have on the DV classes? You were doing the ones in jail.
Yeah, I already did 5 classes.
How many are there?
There's 12-week class. I've already done 5 of them.
You're about halfway through.
Correct.
All right. So I know we were trying to get him to a certain point so that he didn't lose that, but so I'll adjourn this pretrial to June 4th, 2025, 9 a.m. I don't want to go, if we have to do another adjournment, we'll do it, but you've been in contact with Miss Blair.
Yes.
Okay. Okay. I don't know where you guys are in your discussions, but then have Miss Blair get in touch with me so we can see if we can maintain his housing security.
Okay.
Okay.
I appreciate it. And if I may ask, is his bond on this case personal bond? If we do resolve the DV case issue?
I do, yes.
Okay.
I think the last time we were talking about his housing, I set a PR in this case
Okay.
so that everything will be clear.
So if I get released, would I be on a GPS tether, correct, on the DV?
I'm not sure under what terms we would do the release. Okay, or that we're going to do it even. I know that we were trying to make everything work out for you on that. Okay?
Thank you.
All right, thank you. Court recalls for the second time, case People versus Gabrielle Boyd.
Morning, Judge. Ada Spahich on behalf of Ms. Gabrielle Boyd, who's present via Zoom. Judge, again, thank you so much for passing this matter.
Ms. Boyd, can you state your name, please?
Yes, Your Honor, Gabrielle Elise Boyd.
Your counsel told me to issue a bench warrant.
This is courtroom tension at its sharpest. A bench warrant was on the table, and narrowly avoided. That matters. Warrants escalate everything. Arrests, jail holds, bond increases. What stands out is the judge's acknowledgement of defense advocacy. Counsel stood up. The court waited. That cooperation saved Ms. Boyd from immediate consequences. From here, the case shifts into logistics, discovery, travel, Zoom appearances. But make no mistake, these permissions are privileges, not rights. International travel while on bond is never guaranteed. The judge's eventual flexibility shows something important. Credibility. The court believes this defendant will come back. That belief shapes outcomes more than most people realize. Ask yourself, should personal milestones ever influence court decisions? Or should the law be blind to life events?
She told me, she said, go out and find her. I had faith that she'd show up. I'm just letting you know.
I'm so sorry, Your Honor. I would never leave you guys. I would never do that. I would never stand off like that.
Okay.
Thank you, Judge. I
It's
appreciate it.
No.
Fire me and then we'll figure it out.
No. The reality is your client, your counsel stood up for you and had me pass it and everything and had me not issue the bench warrant.
I
Okay.
appreciate that so much.
All right.
Thank you so much, Judge. Last time we were here, we adjourned the pretrial because I needed some time for discovery. I have received all discovery. I have reviewed it. I am speaking with the sister council with respect to just if there's a way that we can resolve this case. There might be some potential legal issues in the case. I just needed some more time to discuss it with Ms. Landy because we might be able to resolve it short of me filing a motion. So that was just going to be a quick adjournment, and I wanted to address the bond as well, Judge.
All right. So will the 4th be enough time for you? Or
So, Judge, this is another thing. If I could, I know. I'm sorry, Judge.
man.
I know.
No, go ahead. We're taking all
day.
day with this case anyway.
I know. I might as well, I am going to be going out of town to visit my family back home in Bosnia. So I work when I'm there as a sole petitioner. I can't really take a lot of time off. So I work while I'm there. So I'm going to be appearing via Zoom. If you could give me the June 18th date, just because I'm traveling on that 3rd and 4th, it takes a long time to get there. If you could give me the 18th date, I can appear via Zoom if this is okay with you, Your Honor, and obviously allow my client to appear via Zoom. I will be working. I will be in communications with Ms. Landy.
That's fine.
Um,
We'll do that for you.
Thank you, Judge. I appreciate it.
All right. June 18th, 2025, 9 a.m.
Thank you, Judge. And
As your invite indicates, yes, that's the bond.
just with the bond, yes. Judge, you previously granted my client a request to travel with her family on a cruise starting tonight, until May 31st.
I did that?
Yes, Judge, that was granted. However, I did not take into consideration the travel time back from Europe. So she's actually coming back June 1st. So I was going to ask for just that one additional day. I didn't want her to just assume that she can come back on June 1st without asking you directly, Judge.
Trying to see, did I sign an order? I did. Okay. And so your travel date is the 1st of June.
So we fly back the 31st from Barcelona, but apparently time-wise, since they're 6 hours ahead, it will be the next day. So that's what my mom told me, at least, is that we will be arriving early on the 1st, but we will be departing for travel on the 31st.
You know what? You've got till June 2nd to get back. I'm not going to do international datelines or anything. I'm done. I'm done with
It's a
that.
6 hour
So
difference,
you
Judge.
have till June 2nd.
Okay, I'll for sure be back by June 2nd, for sure.
Okay.
Perfect, Judge. And then one more request, and I will leave you alone,
Oh,
Judge. I
really?
swear, I know you're gonna.
Really?
make fun of me. At least I don't come
It's
here that
my
often.
fault.
No, you don't.
You know,
but
so
when you're here, there's a lot of requests. Go ahead.
Yes, Judge. So my client has twin sisters who are, who have their last performance as the lead of their Broadway musical in New York. So the whole family is going to that
What?
show from June.
So they're
6th
going to
through
Barcelona and New York.
No,
In June.
so
That's in
mine-
June.
Yes.
So that's from
mine-
June 6th to the 9th, and I'm respectfully requesting that you allow my client to travel to New York with her family from the 6th to the 9th to attend the show, the musical, that her twin sisters are participating in.
So hold it. She's going to Barcelona. She comes back. I've
Correct.
given her to June 2nd.
Correct,
She's then gonna basically catch her breath and then she's off to New York.
And then,
yes,
yes.
which is gonna be very tough, because I travel to Europe quite a lot and it's exhausting.
My twin sister has been the lead of a Broadway musical for the last year and a half. Her
So hold
last.
on. It's not it's your twin?
It's my twin sister. She's my twin.
Oh,
Yeah.
no.
Sister's not.
There's like 2 of them.
Yes.
There's like 5.
Well,
There's
there's-
five daughters.
I know, but there's 5 daughters.
I believe so,
Yes.
right, Miss Boyd? Okay.
Yes,
Wow.
there's 5 of us total, and she is extremely hardworking, a U of M musical theater graduate. It's really important to her that I be at her last show, she's expressed to me. And
She
I
wants
also,
her twin there.
she has stated that to me very clearly, that she wants me.
So I'm supposed to do this for her.
For me, Your Honor, because I would really love to be there to support her. I would be traveling via train with my grandfather to take him, because it would be his last opportunity to see her. So
Oh,
it's,
okay.
yeah.
You sold me. I'm done.
Okay.
I'm done.
Thank you, Ms.
What
Boyd.
dates? What dates are there?
This is persuasion in real time. Ms. Boyd's explanation wasn't legal. It was human. Family. A final Broadway performance. A grandfather's last chance to attend. Judges hear excuses daily, but sincerity cuts through. What sealed it was specificity. Dates. Travel methods. Return plans. Vagueness kills credibility. Details build it. The judge still protects the court. Written orders, formal approval, clear deadlines. Compassion doesn't mean chaos. This moment reminds us that justice isn't robotic. It's structured discretion. And when used well, it keeps people engaged with the system instead of alienated from it.
June 6th to June 9th. We will be back the 9th.
Counsel, if you can prepare an order.
I will, Judge.
Fine, just, that includes both of your clients.
I will make sure I prepare a new order.
All right,
It'll include both, and I'll make sure I file that today.
thank you.
Thank you, Judge. Thank you so
Take
much for your
care.
patience. Thank you,
And
Ms. Boyd.
Godspeed to all of you on your journeys.
Thank you so much, Your Honor. I appreciate you.
You're welcome. Calls the case, People versus James Jance. I don't know. I'm gonna, yeah, at some point I've got to break. It's been going a while here, but.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Jance, who stands to my right, please state your name for the record, sir.
Thank you.
Thank you, Your Honor. There is a resolution in this matter to which Mr. Jance will be accepting the offer extended by Mr. Stiller, pleading guilty to the charge of MCL 257326, and in exchange, count 1 will be dismissed.
So, Your Honor, I move that counsel allowing an ineligible person to drive, MCL 257. You accept that guilty plea. I move this original charge.
Have him sworn.
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth? Yes. State your name.
James Jance. Sir, this is court's understanding you're going to plead guilty to the charge of allowing an ineligible driver to operate a motor vehicle. Is that correct?
Yes.
That's a misdemeanor. It's punishable by up to 90 days jail, $100 fine plus court costs. You understand that?
Yes.
Still wish to plead guilty? To that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form today, is that correct?
Yes.
Any question regarding any of those rights?
No.
Look at paragraph 5, you'll see a copy up there. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
Bless you. You understand you're giving up your right to appeal over.
Yes.
Are you on probation or parole? Has anybody promised you anything in order to get you to plead? Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And because you believe that you are indeed guilty of this offense? On the date. Oh, no, she's coming back. On the date of January 21st, 2018. Is it 18 or 19?
31.
2019. Location of Carpenter Road near Washtenaw Avenue in Pittsfield Township, Washtenaw County, State of Michigan. Did you have custody or control of a motor vehicle?
Yes.
Did you allow someone who is otherwise ineligible, maybe inclusive of yourself, to operate that motor vehicle?
Yes.
Counsel, have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 2, count 1 is dismissed. Anything you want to say before I impose sentence in this case?
Just briefly, Your Honor, I would ask the court to consider sentencing my client to the state minimum fees and time served. It's my understanding he served about 31 days in custody. He's being held on another matter on a $10,000 bond. I would ask, given that, the court would consider the state minimum and time served for sentence.
Sir, anything you want to say?
No.
$125 statutory fees, 31 days in jail, credit 31, sir.
Thank you, Your
Thank you.
Honor.
Court calls case People versus Ashton, Eibler.
People,
Assistant Public Defender Natalie Pate with and on behalf of Mr. Eibler, who appears via Zoom. Sir, can you please state your name for the court?
Ashton Eibler.
All right, what are we doing?
Thank you, Your Honor. I believe we are very close to a resolution. I'm respectfully requesting a very brief adjournment. I did provide some documentation to the people, and I believe they just need to check with the officer in charge.
June 4th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you.
Thank you, sir.
Court calls the case People versus Carl Tinsley.
people,
Is that what Johnson was here on?
yes.
Is that, you gotta watch, Alan, did you see him sitting over there in the corner? He was hiding. He comes in here and hides. Go ahead.
Good morning, man. Please, this Honorable Court, Kareem Johnson, on behalf of Carl Tinsley, who's approaching from custody.
They're bringing your name, sir.
Carl Tinsley.
Thank you. Yeah, just step over. Yeah, there you go. All right. Okay, what are we doing?
Your Honor, we ask this matter be set for jury trial.
Jury final settlement conference, June 6, 2025, 9 a.m. Jury selection, if necessary, June 9th, 2025 at 8:30. Both of those proceedings are in person.
Your Honor,
I'm sorry. I'd like to speak.
Okay, hold on. Yeah, counsel first.
I have jury selection Lawrence Buckner in the Ypsilanti District Court on June 9th.
Jury selection
Yes, Your Honor.
before Judge Barr.
Yes, Sean.
to be here.
Okay,
We all slept on the same day.
all right.
Your Honor, if I may,
Yeah.
so Mr. Johnson and I are at a fundamental difference in defense strategy. There's no point in us moving forward together on this case. Mr. Johnson is representing me in circuit court. I've submitted a motion to have Mr. Johnson removed his counsel in that case. Excuse me?
Why?
Why? Because Mr. Johnson is totally uninterested in this case, in that case, in this case as well.
Mr. Tinsley, you've been before me before, and I'm just gonna tell you this.
Okay.
I haven't known Mr. Johnson necessarily all that long,
Okay.
but I'm gonna tell you for maybe about the past year plus that he's been appearing before this court, there has not been a client that he has walked into this court where he has not been interested in their case and zealously representing his defendant. So I don't believe you. You coming before telling me that about this attorney, I don't believe it for 1 minute. Not 1 minute.
This is a hard stop. When a defendant accuses counsel of disinterest, courts take it seriously. But they also protect the integrity of the process. Judge Simpson shuts this down decisively, and for good reason. Attorney-client disagreements don't automatically equal ineffective assistance. The judge's reaction signals experience. He's seen this pattern before. Frustration misdirected at counsel. Resistance to advice. Strategic disagreement framed as neglect. Once the judge says, "You're done," the conversation is over. That's authority being enforced to prevent derailment. This exchange shows how quickly courtrooms can pivot from patience to control. And it's a reminder, credibility is currency. Spend it recklessly and the court closes ranks fast.
I think, because you've been before, is that you're probably not listening to him. He is advising you. I can guarantee he's protecting every right you have.
And you'd be absolutely wrong.
Fullest.
I have not seen, this gentleman has told me he's going to show up to see me countless times at the county jail. He has not. I've been waiting over 2 years for discovery in another case at all. This gentleman doesn't answer his phone. You're making these assertions without having personal experience.
I'm done.
I'm
done. If you want to file
a tool for defense.
If you want to file, Mr. Tinsley, you're done. You're done. You are done.
Yeah, I think I need to respond to the 2-year comment. Mr. Tinsley does have a matter that's been pending for 2 years. I'm the 4th attorney on that matter.
I know.
I have only been representing him since April. When I go to speak to him, he doesn't want to talk about what I want to talk about, Giannis. So I just want to clear that up for the record.
And Mr. Johnson, I meant my words sincerely. I've dealt with Mr. Tinsley before. This is a game he plays. So I'm done.
This moment is important because it illustrates a hard boundary the court will not cross. Once the judge determines that a defendant is attempting to manipulate the process, whether intentionally or out of frustration, the court's priority shifts from accommodation to control. Judge Simpson explicitly frames this as gameplay, which is judicial language for perceived bad faith. From a legal standpoint, the judge is protecting the integrity of representation. Courts are extremely reluctant to remove counsel midstream unless there is clear evidence of incompetence or conflict. Mere dissatisfaction is not enough. The judge's firm defense of counsel also signals something broader. Defendants cannot derail proceedings by attacking their attorney when outcomes are not going their way. This exchange also shows the asymmetry of power in the courtroom. Once the judge ends the discussion, it's over. There is no appeal in the moment, no debate. That finality is intentional. Without it, high-volume dockets would collapse into argument. Viewer question: when a defendant feels unheard, where should the line be between protecting their rights and preventing courtroom disruption?
All right. You're still on this case, regrettably, but you're still on it. All right. Take care, sir. Court calls the case, People versus Otis Elliott.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Elliott. Mr. Elliott, please state your name for the record.
Otis Elliott.
My client and I have spoken about this case. We are asking for an adjournment. It's a little bit old. We are going to do investigation into things, speak to people about.
Well, it's old because he was like bench warrant.
He wasn't bench.
He was
pressed
like
very
2
long.
years. That's why he's old.
Yeah, but he's back here now, so
Well, kinda. All right.
hopefully we'll get things back.
So you want another adjournment to what day? What, you want the 18th or
I'll
the
take
4th?
18 if that's okay. Thank you.
You're gonna come back, right?
Yes, sir.
All right. June 18th, 2025, 9 a.m. All right. Take care. We'll see you then.
Thank you, Judge.
Thank you. Court does call the cases of the people versus Sarah Gray.
Conrad Silver on behalf of Pittsfield Township.
Ashton, for the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Miss Gray. Your Honor, I have not had contact with Miss Gray. I did provide her with information. I'm not sure if she's present.
Are all three on?
The bottom one is we don't have.
She's not on Zoom.
I have no explanation for her. For the record, I requested.
Bench warrants will issue for the defendant's failure to appear in these matters.
This is the fastest way a case escalates. Silence, no appearance, no explanation, no communication. Courts view failure to appear as a direct challenge to authority, and the response is immediate. A bench warrant changes everything. It authorizes arrest, increases bond exposure, and often eliminates prior leniency. Even if the underlying case was minor, the warrant itself becomes the dominant issue. The judge sets bond at $5,000 with a 10% provision, but the real cost is uncertainty. An arrest can happen at work, at home, during a traffic stop, anywhere. What's striking here is the lack of emotion. The court doesn't scold. It doesn't speculate. It simply acts. That neutrality reinforces a key principle. Responsibility to appear is absolute. This moment is a warning to every defendant watching. You courts will work with people who communicate. They will not chase people who disappear. Ask yourself, should failure to appear always trigger a warrant, or should courts build in a short grace period before escalating?
Bond will be set in the amount of $5,000. I'll give a 10% privilege on each case, and each case will issue immediately.
What was the bond that was on the
5,010.
on the felony as well?
The felony, actually, I don't think. Felony already has a warrant.
That's okay. Thank you, Your Honor.
Court calls the cases of the people versus Christopher Minor.
That's a lot of people.
Conrad Silver on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Minor. State your name, Mr. Minor, please.
Charles Minor.
Thank you.
So, Your Honor, we have made a little bit of progress. We were waiting to see what happens with the felonies. He has pled on those felonies to all misdemeanor cases, or all misdemeanor charges. His sentencing is scheduled for June 5th, I believe. I'm sorry.
On the misdemeanor cases? On the
sorry.
felony cases that are now misdemeanors.
The sentencing is scheduled for June 9th. So we're just asking for a date after that to see what he's sentenced to, and hopefully, if, depending on what it is, get some parity with these.
Got it.
sentences.
So you,
This is a quieter but strategically important moment. Mr. Minor's cases show how charges evolve over time. Felonies reduced to misdemeanors, sentencing pending elsewhere. Defense counsel is carefully sequencing outcomes to avoid stacking penalties unnecessarily. Parity is the key word. It means fairness across related cases. Courts often consider what a defendant has already been sentenced to so they don't overpunish for overlapping conduct. That's not leniency, it's proportionality. The judge agrees to wait until after sentencing on the other matters. That decision could significantly reduce Mr. Minor's total exposure. Timing matters in criminal law. Days and weeks can alter leverage, outcomes, and consequences. This exchange highlights how experienced defense attorneys manage systems, not just charges. They're not arguing innocence here. They're managing damage. Engagement question. Should courts always consider outcomes in related cases, or should each case stand entirely on its own?
June 9th is when his sentencing is on those other ones, right?
Right.
All right. So I'll adjourn these out then to June 18th, 2025, 9 a.m.
Thank you, Your Honor.
All right.
Thank you.
All right. Thank you, sir. Court calls the cases of the people versus Larry. Is it Wima? Yeah.
Good morning, this is Senator Lauren Kearney on behalf of Mr. Wima.
You don't have him in Zoom?
Okay, well, I did speak with him, Your Honor. He does have a valid license now. I'm not sure why he's not here. I did provide him with the necessary information. I would request an adjournment on all three cases.
He has a valid. Yeah, he does. So there would be some type of deal on these, correct?
Yes, that's what I'm hoping for.
All right, I'll adjourn it out one time. I'll grant you the adjournment. June 4th, 2025, 9 a.m. on all matters. Figure out what we're. Court does call the case of the People versus Daniel Sims.
Ashton, for the people.
Assistant Public Defender Natalie Pate with on behalf of Mr. Sims, who is approaching. Please state your name for the record, sir.
Mr. Sims, Daniel Sims, sorry.
Thank you, Your Honor. I have discussed this.
I'm not all the way awake, I'm sorry.
You don't know your name? All right, no, go ahead. You're all right.
At least you said Mr. Sims. I mean, it's still correct.
I just repeated her, I'm sorry.
So, Your Honor, I have discussed this matter with my client as well as the people. We are wishing to set this case for final settlement conference at this time.
All right, jury final settlement conference for Mr. Sims will be June 6, 2025, 9 a.m. Jury selection, if necessary, June 9th, 2025 at 8:30. Both of those proceedings are in person.
Thank you.
All right. Thank you.
Thank you, Your Honor.
Go back and get some sleep. Court calls the case of the People versus DeJohn Holmes. 3 cases.
Ashton, for the people.
Pardon?
Conrad Silver on behalf of Pittsfield Township.
Court calls the case People versus Jason Williams.
Ashton, for the people.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Williams. Ms. Williams, please state your name for the record.
Jason Williams.
No, we're here for pretrial hearing. I also filed a bond motion on behalf of Mr. Williams.
All right.
I would rely for the most part on the written motion. However, I do want to emphasize a few things. I did speak with Mr. Williams, his therapist at his substance abuse treatment center. He did do a number of sessions before being incarcerated, his bond being remanded, including 8 group therapy sessions, 6 individual therapy sessions.
This is a full mitigation presentation, and it's done correctly. Defense counsel doesn't rely on promises. She presents verification, treatment records, employer statements, specific numbers of sessions attended. That level of detail signals seriousness. The court is being asked to balance risk against rehabilitation. On one side, a positive test and prior noncompliance. On the other, active treatment, employer support, and willingness to submit to monitoring. This is where bond decisions are hardest. Mr. Williams' own statement matters more than it seems. Judges listen closely to accountability language. I've grown. I have to obey the law. That framing aligns with rehabilitation rather than entitlement. The judge ultimately sets a $25,000 personal recognizance bond with scram monitoring. That's conditional trust. When freedom paired with surveillance. Audience question, does electronic monitoring support recovery, or does it simply delay punishment?
Sessions in 8 AA sessions. She did indicate due to his positive test, they'd love to see him back, and that they would recommend extending his treatment for an additional 90 days. I also spoke with his employer. They gave him a 30-day leave of absence. He is welcome to go back to his job if and when he is released. And they all
Works
seem
at U-Haul.
at U-Haul, correct, in Novi. They all seem very happy with Mr. Williams' performance, and do want him back. He has been in custody for 28 days as of today. So given that, I'm asking for the court to consider releasing him on a personal bond. We've spoken many times since he's been remanded. I think this is the first time he's ever done any time in jail. He's had a lot of time to think about his choices, and I think he's ready to get back on the wagon, get his life back on track, and take care of what he needs to do. He's willing to provide the court with progress reports of how his treatment is going. I think he'd be willing to wear a scram tether or any increased bond conditions the court may recommend.
Anything from the people?
Now, with a history of non-compliance while on bond, the people would request electronic monitoring of some kind, preferably a scram tether, perhaps just for the interim, to make sure that the defendant is not going to be taking a lot of bond with this operating while intoxicated offense.
Anything you're gonna say, Mr. Williams?
No, sir.
An educational experience for your husband.
Yes, doing these 28 days when I was here, I did learn a lot. I did become better. I had a lot of time to think. I have grown since I've been here. Like, at the end of the day, you have to be responsible. You have to obey the law. You have to do what you need to do and be able to just act the life and do what you have to do when it's all said and done.
Sorry you took this for it to come to that, but however, we have to learn that, right? I'm gonna set his bond at a $25,000 personal recognizance bond.
This bond ruling reflects structured mercy. A personal recognizance bond at that amount sends a message. The court is giving the defendant room to succeed, but the leash is short. Scram monitoring isn't symbolic. It's constant verification. What's important is what didn't happen. The judge could have denied bond outright. Instead, he creates a controlled environment for recovery. That choice suggests belief in treatment over incarceration, at least for now. This moment also underscores how employment and treatment intersect with legal outcomes. Without those supports, this decision likely goes the other way. Viewers should note, courts reward preparation. This didn't happen by chance. It happened because counsel brought evidence, not excuses.
With his previous conditions reinstated. Scram tether prior to release from.
Thank you, Aaron.
All right. And then how much time did you want me to adjourn this out?
I think June 4th should be sufficient. I just need to have another conversation with Ms. Londy.
Adjourn it to June 4th, 2025, 9 a.m. All right. Thank you, sir.
Thank you, Aaron.
Court calls the cases of the people versus Germaine Nathan. 3 cases.
On behalf of this township.
And Ashton Lonnie for the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Nathan, who is present via Zoom. Sir, can you please state your name for the court?
Germaine Nathan.
Thank you, Your Honor. I have discussed this matter with my client, all 3 of the cases. There was an offer extended in the township case. Ultimately, we're asking for a 4 to 6 week adjournment in all 3 cases to see if Mr. Nathan can become validly licensed.
Okay. So he's trying to get his license back.
He is. He just needs to check on some things. But yes, Your Honor.
I'll adjourn July 2nd, 2025, 9 a.m.
Another license-driven case. Another reminder of how administrative penalties entangle people for months or years. Mr. Nathan's situation isn't about a new offense. It's about restoring legal eligibility to drive. Adjournments like this are conditional patience. The court expects progress by the next date. No progress means patience ends. License cases often look small, but they affect employment, family obligations, and compliance with every other court order. Driving illegally to get to work can undo everything. This is the system buying time, but not indefinitely.
Thank you, Your Honor. Thank you, Mr. Nathan. You're all set.
Thank you.
You're welcome.
Sorry. Court calls the case people versus Rick Artuso.
Ashton Lonnie for the people.
Probably, yeah. Artuso. You don't. Got it. Go.
Thank you, Your Honor. Assistant Public Defender Natalie Pate with and on behalf of Mr. Artuso in 2 of the matters, but not on the case ending in 217. I believe that is Mr. Burgess' case, Your Honor.
It is. And do we know, anybody know whether Mr. Burgess is gonna?
I have not had communication with him, Your Honor. No, I cannot speak to that.
Got nothing from him this morning. Okay, well, what were you gonna do on your case?
So we were going to ask for a very brief adjournment so I can confirm the status of my client's license and provide that to the people. I have discussed this matter briefly with them regarding both of the cases I am on. So I'd request a very brief adjournment. He is being held on a felony matter with his next court date being the 29th
Of
May.
May. Okay. Well, why don't I do this? There must be some mix up because Mr. Burgess is usually here. Have you spoken with him, sir?
No, I have not, Your Honor.
You haven't? Okay. Then there's something.
And Your Honor, Ms. Payne, I believe did alert me as well to the 2 ticket cases. It may be duplicated. So it may be duplicate files. So I need to review those as well. So the 6/4 date, if the court would be so kind, would be one.
Yeah, I will adjourn it to that day. We'll just put it out to June 4.
This is courtroom housekeeping with real consequences. Duplicate files, missing counsel, unconfirmed license status. The judge chooses order over haste. Adjournments here protect the defendant from inconsistent rulings. They also protect the court from error. Rushing messy cases creates appeals and reversals. Notice how responsibility is delegated. Defense counsel is instructed to notify absent parties. Courts expect attorneys to manage communication gaps. This moment reinforces a theme of the docket. Organization matters. Chaos costs defendants time and credibility.
All right.
Thank you, Your Honor.
And Ms. Payne, if you could be so kind as to, for your client's sake, let Mr. Burgess know.
Absolutely.
Okay, okay. So, sir, I'll adjourn this out June 4th, 2025, 9 a.m. All right?
Thank you.
Thank you, sir.
Thank you, sir.
Court does call the case of the people versus Rashad Shaffy.
Conrad Solar on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Shaffy. State your name for the record, please.
He's in jail.
Yes.
Mr. Shaffy?
Hello,
Hello. State your name.
Rashad Shaffy.
Thank you.
Your Honor, I'm
He's
requesting.
not driving, is he? Stop.
Hey, do you see me?
Moving. You're a passenger. Okay.
Well, Mr. Shaffy is maybe on his way to Bear River right now. He's going to Bear.
Where you're heading?
That's exactly where I'm going. I got these gentlemen that picked me up at Bear River or at my house, and we're going.
Okay, everybody's gonna wave now.
I like the view.
All right.
So as part of the plea agreement, if Mr. Shaffy completes treatment, this case will be dismissed. So I'm asking, he may be there for a 30-day period or 60-day. As the court knows, there's an assessment that's done. And so I asked maybe go out 30 days, and if he's still there.
Yeah, I got you. So I'll go to July 2nd.
Okay.
2025. 9 a.m.
Thank you so much, Your Honor.
Not a
Appreciate
problem.
you letting me go to retreatment.
Not a problem, sir. I appreciate that you had the courage to do it.
This is one of the most human moments in the entire session. The judge openly praises the defendant for entering treatment. That matters. Courts don't always say this out loud. Treatment-based dismissals are powerful incentives. Complete the program and the case disappears. Fail, and it comes roaring back. The judge's familiarity, we go back 30 years, adds context. This isn't a stranger. It's someone the system has seen before. That history cuts both ways, but here it supports intervention over punishment. Viewer engagement. Should treatment completion erase criminal charges, or should accountability remain on the record?
Mr. Shaffy and I go back 30 years, Your Honor. So,
Really?
I'm familiar with it.
All right.
So, yeah.
All right. His bond will continue. Mr. Jaffe, good luck to you, sir.
Thank you so much.
Today's docket shows the justice system in its most realistic form. Not dramatic verdicts, but constant judgment calls. Licenses suspended and restored. Bonds tightened and relaxed. Travel granted and denied. Every decision balances accountability, risk, and the possibility of rehabilitation. Judge Simpson consistently applies structure with discretion. Defendants who communicate, show progress, and follow rules receive patience. Those who deflect blame, disappear, or undermine the process face swift escalation. Across these cases, one principle stays constant. Credibility determines outcomes. From OWI pleas to housing risks, from treatment opportunities to bench warrants, The court isn't just responding to past behavior, it's shaping future choices. And that's the real weight of these proceedings. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.